Good morning. My name is David Van Zandt. I'm the dean here at Northwestern's Law School, and I just want to welcome everyone to Chicago and to the law school. And I'm really pleased you could join us for this conference today. We are really excited to have an outstanding group of leading academics, judges, and practitioners assembled to discuss the policy implications of recent empirical research in the area of tort reform. First, I'd like to start out to thank our conference chair, Henry Butler, and I'll say more about him in just a minute when I introduce him. I'd also like to give a special word of thanks to Professor Fred McChesney, who actually can't be with us first thing in the morning, but he will be here later on. He has been serving as the interim director of Northwestern Law's Searle Center, and he's really been instrumental in launching the Searle Center and its various programs. And he has been very ably assisted by Derek Gunderson. Where is Derek? Around here, who will be around all day to help you out. Well, he's off working someplace right now. So, and they've done a great job along with Henry, of planning and organizing this conference. The Searle Center was created just this past year at the law school here at Northwestern, and it was established with a gift from longtime philanthropist and Northwestern University trustee Daniel C. Searle. The purpose behind the center is to engage in research on how government regulation and the interpretation of laws and regulations by the courts affect business and economic growth. And its other main goal, in addition to conducting research, is to try to disseminate that research to important public policymakers and to the public in general, so that we can have a better informed debate about the kinds of issues that the Searle Center will tackle. The center draws upon the expertise of scholars in law, business, economics, and public policy, and it seeks to offer rigorous interdisciplinary research on topics such as the one we're discussing today, or environmental protection, eminent domain, corporate governance. And as I mentioned, today's topic, tort law and the impact of tort reform, is an especially important area of focus for the center. As you know, it's certainly an area of hot debate and extremely strong conflicting viewpoints. What I believe, and I think the center believes, is what's missing is a good understanding of what is actually happening, a good, sound empirical research on what is going on. The Searle Center hopes to add to our actual knowledge by asking questions like, what is happening and how are both plaintiffs and defendants effective? Also, how well do policy changes actually work, both in terms of their own goals, but also in terms of social welfare? The Searle Center is seeking to advance the ball, not to just be another forum for shouting matches between the partisans on both sides. Well, I'm now pleased to introduce Henry N. Butler. Henry is currently a professor of economics and law at Chapman University. He is the director of the Judicial Education Program of AEI Brookings Joint Center for Regulatory Studies. He has published numerous scholarly articles and books on a variety of topics, including economic analyses of laws regarding corporations, antitrust issues, and government regulation. His book, Economic Analysis for Lawyers, is the primary casebook for the AEI Brookings Joint Economics Institute for Judges. He is a member of the board of advisors of the National Legal Center for the Public Interest, the Atlantic Legal Foundation, and the Washington Legal Foundation. He received his PhD in economics from the Virginia Polytechnic Institute and State University, and his JD from the University of Miami School of Law. And finally, he got his bachelor's degree in economics from the University of Richmond in Virginia. He's a leading public policy analyst and law and economics specialist. He's devoted much of his career to improving the country's civil justice system through judicial education programs. And finally, he's going to add one more feather to that cap. As of today, he will become the executive director of the Searle Center here at Northwestern, and we are very pleased to welcome him both to our faculty and to the university, and we look forward to a great deal of more of this and other tremendous leadership in this area. So thank you very much, Henry. So.
Thank you. Thank you, Dave. Well, thank you. In putting together this program, the design is to show off a lot of the great work that's been provided here at Northwestern, but to do it in a very fast-paced, dynamic framework so that we have the give and take of a lot of views, but we keep you awake at the same time. So most of the speakers are limited to about 10 minutes for their presentation. It's a lot more difficult to write a 10-minute talk than it is an hour-long talk. So they're going to be very focused in what they do and what they have to say. We're going to start off with an opening lecture by Marshall Shapo, who's the Frederick Vose Professor of Law here at Northwestern. There are detailed bios of all the speakers included in the notebook. Marshall is a great person to start this off with because he's an incredibly well-known tort law scholar, has been very active in many public policy debates. So please welcome Marshall Shapo.
In our small corner of professional life, we are yet surrounded by the rushing of the currents of history. In order to speak of litigation and tort reform, we should begin with torts and with history. In 1984, I began a 1,000-page monograph on the subject by noting that so far as we know, there is no word in the Bible for torts. Yet I also observed that the norms which the Creator told Moses to set before the Israelites in the chapter of Exodus following the Ten Commandments are filled with what we think of as tort rules, an observation which, according to the standards of my profession, I accompanied with a half-dozen citations. So torts is a creature with a history that stretches back millennia. However, as a concept defined under that word, its parentage goes back less than a century and a half. Indeed, it was only in 1859 that the first treatise on that subject was published in this country. A singular historic event was Holmes's publication of the common law in 1881. In that work, reviewing precedents going back to Alfred the Great, and without the aid of Lexis, Westlaw, or even a typewriter, Holmes gave us a rigorously sourced essay that still stands today as a primer for the basic study of the subject. It was, unsurprisingly, for a man thrice wounded in the Civil War, stripped of sentimentality. In setting out an objective test for liability, Holmes declared the standards of the law are external standards, and however much it may take moral considerations into account, it does only for the purpose of drawing a line between such bodily motions and rests as it permits and such as it does not. In the background of this crusty sentence, we can almost visualize the flash of the rifles and hear the boom of the cannons at Ball's Bluff and Antietam and Fredericksburg. Thrice wounded he was. It remained for Pound a generation later to capture another trend in the ancient law, perhaps with a less hard-edged aspect. Pound noted how the law had begun to take account of purely subjective mental injuries to a certain extent, and even to regard infringement of another's sensibilities. At just about the same time, Cardozo drew on precedents on both sides of the Atlantic to construct a remarkable essay on what today we would call consumer protection law. In McPherson, in his inimitable style, he sharply delineated the difference between torts and contracts. He put aside the notion, as he said, that liability for personal injury caused by negligence grows out of contract and nothing else. We have put the source of the obligation where it ought to be. We have put its source in the law. At the same time, there was a sprinkling of decisions in the law of what became called products liability that recognized the blurriness of the boundary between the two great private law subjects. The founding decade of the ALI, in part a creature of Cardozo's insistence It was time to have an organization that would work on restatement and improvement of the law, featured some early committee discussions that are delicious for the modern tort scholar to read. I think in particular of the fierce exchanges between Cardozo and Learned Hand in their discussions of the problem that has been inextricably linked with the name of Paul's graph. A notable contribution to scholarship in the same decade of the 20s, one that has been pretty much buried in the sands of tort history, was the stunning set of articles by Edwin Borchard that suggested that even the king could do a wrong. Synthesis has been a touchstone of the development of tort doctrine. McPherson is a much-cited judicial example. In the late 30s, Prosser provided one of several enduring academic illustrations. He stitched together seemingly diverse lines of cases to propose the tort that became known as intentional infliction of emotional distress. He then presided over the development of that tort with his work as a restatement reporter. Edwin Patterson had noted as long ago as 1921 that it required, as he put it, violent pounding and twisting to make warranty serve the purposes of cases involving defective products. In the early 40s, Trainer's famous separate opinion in Escola gave us a precursor of what became strict liability for products with a rough-edged set of rationales. The brilliance of an émigré, Albert Ehrenschweig, opened up a larger ground of liability in the 1950s. If Ehrenschweig's term enterprise liability has sometimes had unfortunate consequences on scholarship, still the notion that those who create risk should be responsible for injuries typical of their enterprise has endured. In the 1960s, the universe expanded for suits for products injuries. Again, a synthesis by Prosser in a law review article was important. Then Trainer capitalized on his separate opinion in the Escola case in Greenman, writing the first majority opinion that outlined a theory of strict liability for products. Prosser, in his capacity as restatement reporter, concretized the idea with Section 402A. Hard on these developments came an expansion of liability for injuries caused in medical settings. Still controversial is the application of circumstantial evidence rules in medical cases, a subject on which full-dress articles were being written on single-state jurisprudence as early as the 1960s. In the 1970s, courts had begun to articulate a proposition that had seemed obvious to Cardozo, developing a theory of what has come to be called informed consent to vindicate the idea that every person has a right to decide what may be done with his or her own body. The concept of tort reform is an elastic one. We can trace it at least to proposals for no-fault automobile plans, which go back as far as the 1920s. The idea came more fully into public view, viewed as efforts to modify the common law in favor of compensation plans as early as the 60s with the first state no-fault legislation for auto accidents. A leader in proposals to change common law rules to limit existing liabilities for products was our speaker at the noon hour, and my old friend Victor Schwartz, a principal drafter in the 70s of the Model Uniform Products Liability Act. Beginning in the 1960s, the application of economic analysis to law focused in significant part on tort law. A landmark was the celebrated essay by the Nobel Prize winner Ronald Coase. Adding strong momentum to this movement was a challenging book in the early 70s written by Professor, later Dean, and now Judge Calabresi. Along with these events came a rise in statistical studies pertinent to the subject. Deborah Hensler and her colleagues produced important contributions to the statistics of injury. Many scholars, including my colleague Ronen Avraham, from whom you'll hear later, have developed databases that provide foundations for the measurement of the actual effects of law, including changes in the law in the process of litigation. Parallel with these developments came Daubert. Here, the Supreme Court, which has poked itself, perhaps not always wisely, into various branches of tort law in a variety of ways, undertook to set out at least general guidelines for scientific evidence, which extended not only to tort law, but into many other areas. My colleague Albert Yoon, from whom you will also hear, has suggested that there is no evidence that Frye or Daubert makes a difference, but adds sensibly it is time to move away from debating the merits of Frye versus Daubert and toward a broader focus on how judges actually make decisions about science. Questions which perhaps are described as basically cultural have threaded their way through all of this history. One of the most interesting is the continuing argument over whether courts should recognize a separate tort for negligent infliction of emotional distress. As I have observed in my book on tort law and culture, this is a legal subject that reflects various social ambivalences. Pervasive in much of the critical discussion of tort law is the question of what has come to be called non-economic loss, for which there are several subcategories. Using pain and suffering as a major code word, we can observe only that damages of this kind are one of the fiercest battlegrounds in all the subject. A symbolic capturing of the dilemma came from a conservative United States senator who was advocating federal limitations on the amount of money that could be recovered for such damages. However, confronted with a particularly sympathetic case involving an egregious episode of malpractice on a teenager, he allowed as how exceptions might be made, I'm quoting here, where there was proof of gross negligence. People in our business call this the beginning of a slippery slope. With the dawn of the 21st century, the very phrase tort reform has become a subject of quarrel. Opponents of changes in the law that would limit liability have begun to speak of tort deform. It might be better to have a more neutral phrase. In any event, one of the most fascinating developments in the area has been constitutional challenges to changes in the law, in which courts are asked to overrule legislation that effectively curbs litigation. Accompanying that has been the increasing politicization of tort law, as manifested in the enormous amounts of money poured into races for seats on state courts of last resort. Roofing all of this subject is the question of how society does and should respond to various kinds of misfortune. In a recent book, I presented a series of concentric circles ranging from the particularized event of September the 11th, one of the most monstrous of all torts, among other things, through the broadest circle of all. That is, all events that are viewed as misfortune by people struggling with the vicissitudes of life. How one separates responsibilities for various kinds of misfortunes, including compensation for such events, will remain a subject as long as there are conferences on this topic. In my study of more than 20 years ago, I sought to weave together several threads: the history of tort law, the foundations of tort doctrine and the accretions to it over the years, economic theory, and the question of how people actually behave, including the early work on perception of risk that ultimately won Professor Kahneman a Nobel Prize. Mindful now that Holmes spoke in his great dissent in Abrams of how time has upset many fighting face, we can now only ask, as this conference does, how tort law and efforts to change tort law will work out. As was so when Holmes wrote in 1881, and as I surely knew when I attempted to synthesize the overall topic in 1984, that will await the judgment of history.